Shannon Sharpe has settled his lawsuit. Breaking news. Let's talk about it. All right. As you can see here, Shannon Sharpe, the Hall of Famer, settles his sexual assault lawsuit. Now, if you guys remember, I did a video right here back in April when this lawsuit was filed. And one of the reasons for doing the video was because it was very shocking. Shannon Sharpe, as you all know, is a Hall of Fame football player. He has his own podcast. I think he has a couple of podcasts actually, but he's very, very well respected and well known. So when this whole lawsuit came out, it was shocking. And as you can see here in the headlines, as of today, it's being reported that he settled it. And if you look here, it says the Hall of Fame tight end Shannon Sharpe offered, per his lawyer, at least $10 million to settle the sexual assault claim before the lawsuit was filed in April 2025. Now, I actually talked about that part before because I was saying how I thought that was a bit unusual for Shannon's attorney to come out and announce publicly what they actually were offering for settlement. Settlement negotiations by the federal rules of evidence as well as state rules of evidence. And I think this case is in federal court, but it doesn't matter. Most state and federal rules of evidence allow for settlement negotiations to remain confidential and not be used to prove liability, as well as not be used to bring up in trial later. But nonetheless, his attorney came out with it. Not sure what that was about, but that is highly, highly unusual. I don't really see that often. But it says here, now Sharpe will be paying an amount that likely exceeds $10 million by more than a few bucks. Now, they don't know because the details haven't been hasn't been released. No one knows what he paid or if he paid anything. One can assume because his lawyer already said they offered him so much money, but there's no reports of if they were paid. So and how much. But anyway, it says right here from the accuser's attorney, Tony Buzbee. On April 20th, 2025, the Buzbee law firm filed a complaint in Nevada making several allegations against Shannon Sharpe on behalf of our client, the Jane Doe. Both sides acknowledged a long-term, consensual, and tumultuous relationship. After protracted and respectful negotiations, I'm pleased to announce that we have reached a mutually agreed upon resolution. All matters have now been addressed satisfactorily, and the matter is closed. Thus, the lawsuit will be dismissed with prejudice. I got to tell you, from my experience, whenever you hear the plaintiff's attorney stating that there have been respectful negotiations and they are pleased to announce that this matter has come to resolution, that typically is implying that, hey, you know what, we were suing for this amount, and I think their lawsuit was demanding $50 million. So I don't know what they got, but when you have lawyers saying, the plaintiff's lawyers saying that they are pleased to announce, that typically implies that something happened to where they are so pleased with the result, they'll just go ahead and drop the lawsuit with prejudice. And I've already discussed what without prejudice and what with prejudice means. With prejudice just simply means you can't refile this lawsuit again on these same allegations. And of course, without means you can bring it back. But here, he said they're going to dismiss it with prejudice. So they are completely satisfied, per the plaintiff's attorney's own words, we're completely satisfied with this. And it says here, it is common for settlement agreements to contain broad confidentiality provisions aimed at keeping the amount of any payment secret. Now, that is true. It is very true that you have a confidentiality clauses in these settlements agreement. However, in Nevada, where this lawsuit was filed, as you can see here, Assembly Bill number 248, they actually have a bill here in Nevada that went active and that was actually made into law in 2019. Says this bill prohibits settlement agreements that contain provisions that prohibit or restrict a party from disclosing certain information regarding or relating to a civil or administrative action if such an action relates to conduct that would otherwise qualify as a sexual offense punishable as a felony under certain circumstances. discrimination on the basis of sex by an employer or a landlord, or an act retaliation by an employer or a landlord for a claim of discrimination thereof. This bill makes any provision void and unenforceable if it is contained within the settlement agreement entered into on or after July 1st, 2019. So, it looks like it's pointing to, obviously it's pointing to employers, and I don't think she worked for Shannon, so this is not an employee-employer relationship, or a landlord, and I don't think she was his tenant as well. So I don't think this bill would apply, but the part about, if such an action relates to a conduct that would otherwise qualify as a sexual offense punishable by a felony under certain circumstances, they don't outline what the certain circumstances is. So more than likely, there's a confidentiality clause in there, and this bill probably won't apply. And I'm sure that the plaintiff is just going ahead and just mum's the word, not say too much about it. But nonetheless, what do you guys think? Now that this is over, the attorney said, hey, we're satisfied, respectful negotiations on both parts, long-term, consensual and tumultuous relationships, but we are pleased to announce. So what do you guys think happened here? I have my own thoughts, but I've already shared my thoughts. I want to hear from you. You tell me what you guys think. What happened here? Do you think that Shannon ended up paying to get this, to make this go away? And if you do, how much? What do you think? I mean, we don't know. Nothing's been brought out, but you tell me. I want to hear from you. I would love to hear your thoughts on this situation. Like, comment, share, subscribe. It's your brother, Attorney Jeff.